One such example of provisions which I believe will help to modernize family courts and encourage compassionate, thoughtful rulings is a provision to require the court not to draw any presumptions or consider any temporary orders when allocating parental responsibilities or approving a parenting plan.
This is critical. Oftentimes, temporary orders are the exact point where parental rights are won or lost. When a judge issues an unfairly restrictive temporary order, it weaponizes the length of the litigation and undermines cooperation. A parent receiving a favorable order knows the longer it stays temporary, the more likely it becomes permanent. Therefore, they have little incentive to engage in any cooperative process to create a parenting plan. Senate Bill 174 does contain a provision prohibiting the court from considering temporary orders as a factor in making a final decision. Whoops, that was the as introduced version. The bill was amended.
It eliminates a provision that would have prohibited a court from considering a temporary parenting order as a factor in making a final decision when allocating or approving parenting responsibilities.
How do the sponsors explain this change?
Temporary orders themselves cannot be considered when determining the best interest of the child, but the bill expands the best interest of the child factors to include several new provisions, one of which is whether or not either parent complied with the temporary orders.
But does the text of the bill support that explanation? Looking at the best interest factors, it's easy to identify the provision the sponsor referenced. However, nowhere in this provision is the court's consideration of temporary orders limited. Moreover, the very next factor directs the court to consider anything deemed relevant. Thus, anything not expressly prohibited can be considered. Most importantly, the rules of statutory construction permit the court to look at a law's legislative history. In this case, Senate Bill 174 began with a provision prohibiting the consideration of temporary orders, but was passed out of the Senate without it. That signals clear legislative intent to allow the court to consider temporary orders for any reason, thereby continuing a culture in which temporary orders become permanent. So, the claim that courts are prohibited from considering temporary orders is categorically false. And what can we infer from the sponsors continuing to push this narrative 7 months after it became untrue? 1. They didn't read the bill. 2. They don't understand the bill. Or 3. They deliberately misled the House Judiciary Committee. Regardless, continuing to promote verifiably false claims calls into question the veracity of their entire testimony, and should give one pause when considering other claims made by the sponsors.